Okay, good morning, ladies and gentlemen. Who is on time today is our webinar. My pleasure to greet you this nice day. We have sun in Kiev. And hopefully 20-30 minutes we will talk about representative office in Ukraine, some main issues. Briefly, however, I hope to be quite concrete with all the issues we run into while providing services in this area to our clients. So, actually, there in this program you have an option to drop me some questions regarding this theme. So please feel free to write down in that box you may see on your screen questions. Actually, we will collect all of them and I will answer them at the end of our online meeting today. So first of all, I go through some presentation material, some slides. I will deliver you my presentation on this topic. And in the end, in 20, 25, 30 minutes, hopefully I will answer all the questions you will drop to me. Okay, so let's go. I hope you can see the slides now. Well, so first of all, when do we need a representative office? Just generally speaking, it's important because when we go into the details, we should first of all understand why we using this vehicle actually. So first of all, there must be a business need to be represented legally in Ukraine, and in this particular case, the local agent is not enough, which means that your distributor or your representative in Ukraine doing business with you on the usual basis is not enough for you to go further to grow your business. So there is a business need for that. And at the same time, a branch company, so a corporate establishment, let's say LLC, which your company can establish legally in Ukraine, is not required according to some local policies or strategy of the company, or on the other hand, is not allowed or is not actually needed at this particular stage of your development or development of your business in Ukraine. Another factor is, especially for our clients from pharmaceutical market, when the representation itself does not generate cash flow. So actually when we have a unit which represents our interests in the country, however, at the same time, it does not generate cash itself. It provides some services which are very important: marketing, promotion, registration, and so on and so on and so on. However, it does not generate cash flow. In this case, in this particular situation, it could be wise to establish a representative office, which allows us to leverage our taxation and be more effective. So exactly, as you may see on the screen, shortly I summarize these most important points, generally speaking, on this issue. So a few words about the procedure of registration of representative office. As you may see, it is quite, in my opinion, simple procedure, which requires, precise legal work. However, it's not more complicated than establishment of branch company. It's even easier. We need an application, some documents from abroad, extract from trade commercial register, statement from the bank, a couple of powers of attorneys for the head of the representative office, which is most important because it influences on the tax regime you will employ in your representative office, and surely the power of attorneys for the employees who will be engaged in the process of registration of representative office. And the statute or charter of association, doesn't matter how to call it. So the main document which lays in the base of the functioning of representative office, where you stipulate all the actual activities which will be provided by the representative office. Well, I will not read all these specific requisites which should be used in the application for registration. You may see them on the screen. It's, well, usual legal work to be precise and clearly express all the features of your representative office in the application. Just we should pay attention specifically at the sphere of activities of the company, because I will pay more attention on that later. It has influence on the tax regime we will employ, because for I will pay more attention later. So some more requirements to other documents should be met. You will have these few slides sent to you by email at the end of our meeting today. So in case you will need it, you'll just read it for yourself. All these documents should be notarized, apostillized, and in some cases all the translations should be as well made by official entrepreneur here in Ukraine with a license, and he puts a stamp on those translations confirming that the translation is real, precise, and actually reflects the meaning of the original documents. Power of attorneys for the head and for all the employees as well should be provided in original with notarized signatures of the company's head. So, just generally speaking, requirements to the procedure itself, the original documents should be issued in the country of registration, translated. Then it's important they should be submitted to the Ministry of Economic Development and Trade of Ukraine no later than within 6 months from the date of the issuance. Sometimes the procedure of agreeing all the features is a little bit long in time. However, we should meet these requirements, and everything should be assigned not later than 6 months from the date of the issuance of the documents. And some words about payment, because the state registration fee for the representative office amounts to $2,500 United States dollars, and only the Ukreksim Bank of Ukraine has the right to confirm that this registration fee has been submitted and accepted by the government. So there is a specific procedure, however, it's already well-known procedure, and the bank knows how to do that, so no difficulties on this stage will run into, hopefully. Some words about the time. You see, the current legislation provides that the registration of representative office itself takes up to 60 business days from the date of bank notice confirming the state registration fee payment. And actually, you can register it in few weeks. Still, the governmental authority, the ministry, has the right to hold all the documents up to 60 business days. And this is the current possibility for the ministry not to hurry up with your documents. So still, we managed to, actually we have registered already, I don't know, a dozen representative offices and we managed to register them. Usually it takes 2 or 3 weeks, up to 1 month, from our experience. Well, so we have no commercial office and commercial representative office, or we call it commercial permanent establishment. What are the differences between these two possible forms of activities in Ukraine, and whether we can combine them or not? So let's go into details. The non-commercial representative office is an office which does not meet the criteria for permanent establishment. So actually there is particular strict requirements. Your office can be called non-commercial in taxation point of view, first of all, and as you may see on the screen, it's quite specific. It's from the Ukrainian law. And just generally speaking, the non-commercial representative office cannot provide the same, cannot perform the same activities as the mother company, and all its activities could be of auxiliary or preparatory character, generally speaking. And the law just provides some examples which of those activities could be deemed as preparatory or auxiliary characters. Any combinations of these kind of activities as maintenance of stock of goods, fixed place of business solely for purpose of purchasing goods, for purpose of displays or supply, for scientific research, supply of information, purpose of advertising, and so on. So all possible activities which are auxiliary, not main activities of the multi-companies. In this case, the office could be deemed as non-commercial, which provides us with some benefits for using this kind of office in Ukraine. What are those benefits? Advantages, actually, of running such kind of representative office. So, using this vehicle, you have an ability to fund the representative office needs without income taxation. So, from the definition itself, this representative office is non-commercial. It does not generate a cash flow. It does not perform commercial activities. That's why it does not create any income. That's why we have no duty to pay any taxes on the income which does not exist. In my opinion, that's exactly. Going further, there's no VAT taxation because you do not generate income, you do not actually do business in the initial meaning of this word. However, if the representative office sells some, let's say, cars, for instance, or something big, which amounts to the level when the, according to general rules, the unit shall be registered as VAT payer. So in that case, VAT is applied, but exactly on that sum, on that specific deal. You just performed selling something, and on the sum of these goods, you just sell or some cars. Usually it's cars or some stuff, office stuff, but amounting to big sums. In that case, the VAT is applied and paid. The other advantage is the ability to perform registration, advertising, marketing of the parent company's goods without taxation. It's quite important and quite often used by our clients from pharmaceutical industries. However, taking that on board, we should pay attention to the specific requirements of bilateral agreements between Ukraine and the company where your parent company actually is established on the avoidance of double taxation. Because this is a general rule we have in local legislation. However, we have another piece of legislation which is international. Usually it's bilateral agreements with specific country. And there in the specific bilateral agreements on avoidance of double taxation, sometimes there are some specific requirements which should be met while performing activity of non-commercial representative office to be non-commercial, to have this non-commercial status and all those advantages. So you should pay attention to that. And last but not least, in my opinion, is simplified accounting. As far as you do not generate cash flow, you not provide business as business activities, the accounting could be simplified, which is good for administration of this unit. Which are the disadvantages? It is first of all inability to import and trade medicinal products, because and some other products according to the law on licensing in Ukraine, because if you need licensing for doing some activities, you need a business entity as a legal entity, as an LLC, for instance, because representative office is not a business entity, independent business entity. I cannot apply for a license. That's why the use of these kind of special purpose vehicles, this unit, is a little bit limited in some areas. Specifically with medicine, you cannot import and trade medicinal products when you are just a representative office. Second, the only financial source of the representative office is direct filing by the parent company. As far as the representative office is non-commercial, it's like an arm, it's a branch office. It's actually the same company, it's international company, foreign company for Ukraine, and your representative office is an arm and branch in Ukraine, which does not itself independently sells anything to anybody. So the only source for the funding is a parent company, which is on one hand disadvantage, but on the other hand could be as well as advantage, because as far as it does not generate cash here, so you just funds the office. It uses all the funds for activities you agreed on, and from business point of view, it could be quite efficient scheme. So still in disadvantages, I should pay attention to risk of losing of non-commercial status in case of rendering services to third parties. So no services could be rendered to third parties at all. And the tax authorities, especially 2, 3, 5 years ago, they paid a lot of attention to non-commercial representative offices in Ukraine, trying to find any commercial activities within their daily activities, because in case they find them, they applied all the taxation to all the sums that goes through the accounts, which is quite bad and difficult to go through for those offices. And all the main activities of parent company could not be performed as well, because performing the main activity of the parent company is the feature of commercial representative office. For non-commercial offices, it is prohibited. On the other hand, commercial permanent establishment of commercial representative office is a office through which a non-resident, at least partly, conducts economic activity in Ukraine. So, in this case, this representative office has a full capacity for all kinds of business activities, and it is deemed as being independently performing business from the parent company. And it is subject to VAT in Ukraine on general terms as well. So, from taxation point of view, it is being deemed as independent business unit, almost the same as usual legal entity established in Ukraine by non-residents. Why it is still interesting comparing, let's say, with LLC? Why don't the parent company, why don't the non-resident, some company from Western Europe, does not establish just an LLC, but uses this kind of office? So, first of all, taxation. For permanent establishment, for representative offices, commercial representative offices, when it is no possibility to determine income by direct calculation, as a usual basis, revenue minus all the spendings, in taxation meaning of these words. So the taxable income is deemed by authorities as a difference between revenues and expenses calculated by applying the factor 0.7 to the amount of the revenues, which means that 30% of all receipts of the permanent establishment are subject to income tax. So 70% are deemed as expenses. And in this case, the tax burden is 5.4% of the whole revenue, taking in about 18% of taxation on income these days. It should be also noted that tax authorities tend to use direct method to determine the income of the permanent establishment if they find it possible and more appropriate. So it's a little bit tricky. However, if the company sees this opportunity to perform quite simplified tax accounting and uses this approach, and this tax burden is acceptable, feasible, and it's okay for the company, I mean 5.4% of the revenue, so it could be used, and it's quite often is used in Ukraine for some kind of businesses. So, advantages, summing up, its ability to perform all the kinds of business activity which are not prohibited by law, all the kinds. So, however, it is still, and it is disadvantage without any doubts, that inability to import and trade medicinal products and other goods which require licensing. Ability to conduct business with any counterparty, resident or non-resident. So when you have a commercial permanent office, it can sign contracts with residents, non-residents, parent company, other companies without any limitations, and conduct business on the general grounds. Ability to apply the simplified income taxation procedure based on the factor 0.7. In some cases, companies find it appropriate to use this approach. And there are less risks related to tax administration, to risk related to tax authorities' conduct in Ukraine, because in this case, everybody understands, I mean, authorities, that we have a business unit. It does not claim to be non-commercial in nature. It is business-oriented, so all the general rules can be applied, and even some simplified approaches can be applied. which are quite clear. And actually, generally speaking, 5.4% of tax burden on revenue, it could be deemed as quite high tax burden, because usually in Ukraine it is more or less accepted when the general percentage is 1 to 3%. So when the company is paying 5.4%, it is okay, and less attention from tax authorities. I don't know if it is disadvantage or advantage. However, a permanent establishment meeting all the requirements should be registered as VAT payer, and VAT should be paid. In some cases, it's no problem. However, comparing with non-commercial office, where you do not pay any VAT on all the incomes from the parent company, in this case, there is a need to pay VAT on all those sums under the deals, which are subject to VAT, sure, because some of them are not subject to VAT, or VAT equals 0, and so on and so on. So general rules of VAT should be applied. What are the most common mistakes and bottlenecks? A little bit when running a non-commercial representative office, first of all. So, the following activities shall be avoided in order not to lose the non-commercial status. All the services, even a preparatory auxiliary character to any third parties other than the parent company. Advertising, registering medicinal products that are not produced by or owned by a parent company, or rendering any other services to a third party, not a parent company, will be deemed as commercial activity by the authorities, which will lead us to lose of non-commercial status and applying all the taxation on all the sums. Performing any activities mentioned in a certificate from trade register or equal documents, sometimes it is called a little bit in a different way, of the parent company as its main activities. I mean that the non-commercial representative office cannot perform any main activities of its parent company. In that case, if it performs at least one of those activities, sell something, or even advertising, if in the trade register parent company has the right to advertise its business activity, business option. So if the representative office performs the same activity, it will lose its non-commercial status. On the other hand, the following negative consequences could take place should the tax authorities deem the office as a commercial permanent status. So what the actually the outcome when authorities find some business activities in the daily activity of the non-representative office? Income tax. So it will impose on the taxpayer the unpaid amount of income tax and penalties amounting at least to 25% of this amount. Sometimes it goes up to 50% penalties. And VAT. The tax authority may impose on the taxpayer the unpaid amount of VAT and some other penalties related to VAT if all those deals will be deemed as commercial. So, as we see for non-commercial offices, it's quite important to meet all the requirements to the non-commercial status. It is very important. Well, I must say that among all those, I don't know, maybe couple dozens of tax inspections, tax audits with non-commercial representative offices, almost in all cases, tax authorities did find some drawbacks, some mistakes, and we are trying to apply those penalties and taxation in general ways. Because in our reality, I see that companies quite often use non-commercial offices for actually commercial purposes, and under the non-commercial cover, the employees actually perform commercial activities, main activities of parent companies, or provides services legally to the third parties, not to parent companies. So I just ask you to be quite careful while using this approach. And at last, actually, is the final slide of my presentation today. Here's on the screen you can see an example from Ukrainian pharmaceutical market. When a pharmaceutical company is using an approach, while there is non-commercial representative offices in Ukraine and branch office established as an LLC. And using these two vehicles, it is possible to employ all the advantages of the both non-commercial office without paying any VAT, performs marketing activities under the local legislation and taking into account bilateral agreement of avoidance on double taxation. And all those activities are performed surely for parent companies without any business contracts and so on. Just under the articles of association, under the statute of the non-commercial offices, these activities are performed. Cash flow is direct without VAT, just representative offices is spending those money for those activities. On the other hand, we have an LLC, which has the right to perform advertising services under the contracts in this case, either to parent company or to any other companies, because it is an LLC. There are no risks of performing any activities not to parent companies. It is possible to perform all kinds of services to any companies. And a special registration of pharmaceuticals, pharmacovigilance, other services, which are quite often subject to VAT as well. And it can be provided to any companies in Ukraine or outside of Ukraine. So we first of all leverage risks of taxation risks, because we do not cover our business activities under the umbrella of non-commercial status. On the other hand, we employ both of those units in those areas where it is more appropriate for us from the business point of view and from taxation point of view as well. Well, you may say that it is a little bit more complicated, first of all, from administrative point of view. However, in our experience, it could be combined even in one office. There are no any restrictions to that in the local legislation. And if you can manage to divide those activities of those units inside of your office, actually one office, and perform all the bookkeeping, all the document flow properly, this approach can be used and could be quite efficient. Thank you for your attention. Now I'll see the questions and hopefully I will answer all of them. Okay, so what we have here? Just let me ask my assistant if you have any questions. Do we? Okay, we have at least one question. Oh, okay, so it's about possibility to employ one person simultaneously as the head of a representative office and at the same time as a director of another representative office or another limited liability company, and whether it is possible to employ the employees simultaneously in different units, let's say in representative office, LLC, and maybe another representative office. Well, generally speaking, it is possible. There are no restrictions from legal point of view. According to the labor law of Ukraine, any citizen, any employee can be employed numerous times by different entities. In our case, even the fact that one person is the head of representative office and the head of an LLC, which belongs to actually the same owner, which is situated abroad, does not violate anything. Initially, all those units are linked to each other through the owner, and this option, when you employ the same people, does not add any, in my opinion, any additional risks from taxation point of view or other points of view to this approach, to these schemes, to this well, employment approach within the companies. So yes, it can be used. Employees can be employed by different units that belongs to one company or different companies at the same time in Ukraine. And more than that, even as I already said, in one office you can place a few companies, your actually own companies, representative office, LLC, another representative office of the other parent company, and so on. However, from my experience, it is sometimes quite difficult to maintain the order in the document flow, because the same people signing documents and everything is more or less in the same place, and then at the end of the day you have a mess in your business documents and in your business. However, if you can manage to organize everything properly, it's okay and it can be employed. Well, thank you very much for your attention. Briefly, it's all I wanted to tell to you today. So on the screen you may see my requisites. In case you may have any other questions, please drop me an email or just give me a call. I will answer with pleasure. Have a nice day to everybody and good luck.